Your permission. Welcome back from lunch, everybody. We will continue our board meeting. We are on item 29. I need my glasses.
So item 29 is from the Planning Department to conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-693 for Ismael Silva on 8454 Cave City Road, Mountain Ranch, APN 036-012-014.
Thank you. Is everybody familiar with the process, how we do this? Okay, we'll begin with the staff presentation and opening the hearing. And we'll begin with staff presentation.
Very good. Paul Groh with the Planning Department. One thing I wanted to touch on before I get into this, about 9:30 this morning there was a man who came to the counter in the Planning Department saying that Mr. Silva would not be here today. We didn't receive a formal request for a continuance.
You did?
Did not. Either verbally or written from Mr. Silva. However, I just wanted to make a note that that event did occur this morning.
Did the person identify themselves?
No, they didn't. It was a person I believe I saw with Mr. Silva at the Planning Commission hearing. I instructed him that if they wanted a continuance, I needed to hear from Mr. Silva. He could call me. Subsequent to that, there has been no contact from Mr. Silva. The message the man gave me was that there had been a event of some sort within the family that needed his attention.
Let's continue forward. We don't have a formal request.
Very good. Okay, this is appeal number 2016-693. Ismael Silva is appealing a denial of a commercial cannabis registration by the Planning Commission. The reasons for denial by the Planning Commission were the following. The applicant did not produce evidence that no later than May 10th, 2016, that cultivation, grading, or earth moving commensurate with the area proposed to be developed had actually occurred on the site. Second reason was the application for a registration contained false or misleading information. Third, the registrant was in violation of other local law. And finally, the sheriff recommended denial of the registration based upon information discovered during the criminal background check. The site is 2.5 acres. It's at 8454 Cave City Road. That's in Mountain Ranch. It's within Section 10 of Township 4 North, Range 13 East. And you can see up on the screen there, we're right down the road from your previous appeal that you heard Mr. Richardson, I believe, was on actually the corner right there. So we're about 2.5 miles out of Mountain Ranch on Michael Road and Cave City Road. On June 29th, 2016, Mr. Silva filed for a commercial cannabis cultivation registration of 5,200 square feet of mixed light cultivation area. And he was granted an application pending registration in that amount and that use. The first reason for denial was inadequate evidence of cultivation. And this is pursuant to County Code Section 1795-165 N3A and B, which states registrants must provide date stamp photographic evidence of cultivation, grading, or earth moving before May 10th, 2016, commensurate with the area proposed to be cultivated. There was no evidence of grading or earth moving provided in the evidence photos. There were 5 photos submitted. The first 2 we're going to talk about are on the screen up there right now. You can see one is dated April 1st, 2016. The other is dated April 20th, 2016. These photos show cannabis being cultivated within this hoop house structure that you see to the side and behind that. To validate the photographs, we went looking at our aerial evidence. And what the aerial evidence presented to us was that on May 1st, This terrace survey aerial from May 1st showed no hoop house present on the site. When we looked at the Google aerial of May 31st, we found the hoop house structure located to the side of the house there. And remembering that those two photographs were both from April, the dates on those photographs were not, they were in conflict with the aerial evidence that we discovered, and those two images were judged to be invalid. The third photograph, a similar situation. This photograph is dated April 15, 2016. And you can see the cannabis being cultivated. This is the porch of the house. There's actually a porch that runs around all four sides of that house, I'm told. But behind this little cultivation arrangement on the porch, you'll see there's a lot of dry grass and the oaks beyond. And that's April 15th. Comparing that to the terrace survey aerial of May 1st, 2016, you can see the grass on the site and around it is actually quite green. So again, the evidence presented in the photo, the date of the photo, was not validated by actual conditions on the ground, and that photograph was found to be invalid. The last two photographs of the 5 were actually the same image. In the file, there's a small image and there's a large image, and you look at them and you go, that looks the same. Well, when you actually put them side by side and you adjust the scale to an equal size, you can see they are the same image. The issue with these two images is that two cannabis plants are not commensurate with the development of a 52,000 square foot cultivation area. So because the first 3 evidence photos were not validated by the aerial evidence, and these two photographs are not evidence of a commensurate effort at growing the 52,000 square feet, the registration was denied for failing to meet 1795, 165, and 3A and B. The second reason for denial was failure to meet 1795, 178.4. Under that section, the planning director may invalidate any application for registration which contains false or misleading information. There were 3 of these photographs we found met that criteria. I'm only showing the April 1st photo up here, but you'll remember the April 20th photo also with the hoop house structure. And again, looking at the terrace survey aerial May 1st, we don't have the hoop house. When we get to May 31st, we find it on the side of the house. So that appeared to us to be false information. Also, the April 15th photograph, again, the dry yellow grass. That is not what was going on the site. Obviously, May 1st, we still have lots of green grass around the house. It isn't until, May 1st, we still have lots of green grass around the house. And it isn't until you get to May 31st that you see this beginning to dry out. So, for that reason, we judged the 3 photographs to be false, and they were also misleading in our opinion because they represented cultivation that was required to occur on the site prior to May 10th to meet a requirement there, and that doesn't work. So that was the second reason for denial. The third reason for denial was basically construction without permits. County Code, Section 1504.050 and Section R 105.1 of the California Residential Code requires the owner or agent to obtain a required permit before any construction on a structure in excess of 120 square feet. We had 2 structures on this site, actually 5, although we look at the 4 greenhouses somewhat as one, it would be 1 permit, that the registrant failed to obtain permits on before beginning work out there. Over here, it's hard to see, but there are actually 4 greenhouse structures right there in the May 31st Google area. I'm going to go back one slide because I want to show you that terrace server aerial from May 1st. You can see that is a blank cleared area right there. The greenhouses land on the site somewhere between May 1st and May 31st. Again, a check of records with the building department showed that no permit was taken out to do that work. There was also an issue with a shed that was being constructed on the site. Photograph right there shows the shed and some construction going on April 4th. However, there is a code history to this issue. I believe the first time code saw construction on the shed out there was on March 7th. On March 8th, code received a complaint of that construction going on. On March 9th and March 10th, the code spoke with the applicant and told them they needed to go down and draw permits on the work being done on the site. My understanding is that Mr. Silva did actually go down and meet with them on March 10th. However, nothing else was heard from Mr. Silva immediately. There was another complaint on March 17th that construction was still occurring on the site. And after that, on March 21st, code went out and placed a stop work order at the site on the front gate. And with that stop order, there was a request for the registrant to obtain permits within 10 days. They heard no response from Mr. Silva, and because of that, they referred the project back to the planning department with a recommendation for denial. Because Mr. Silva had performed this work without obtaining permits, he was in violation of local law. And under section 1795-170A2, the planning director is giving the authority to, excuse me for one second, invalidate the registration of any applicant who is in violation of local laws on a parcel in which on a parcel which is under the control of the registrant, and therefore he was denied. The last reason for denial was a recommendation by the sheriff for denial, and that comes under County Code Section 1795-165 in 15A1, which allows the sheriff to deny or invalidate the registration of an applicant if the sheriff finds the applicant convicted of a felony or misdemeanor reasonably related to the qualifications, functions, responsibilities, duties expected of the registrant for the registration applied for. Based upon a background check by the sheriff's department and information discovered within that background check, the sheriff found cause to recommend denial of the applicant's application for registration, and that is what was done. Those are the 4 reasons for the denial. So Mr. Silva was denied on, let me see here, on April 25th, 2017, Mr. Silva submitted an appeal to the planning director. In the appeal letter, the appellant asked that the planning department take a second look at the application and provide him with feedback and assistance in getting the application approved. On June 8th, we presented the appeal to the Planning Commission. At that time, Mr. Silva, based upon his desire to obtain representation, Silva requested a continuance of the appeal to a future date. That was actually taken under, discussed among the board members, and it was public comment on that, and it was decided on a 3-2 vote to hear the appeal at the commission on that date, June 8th. The first thing that was reviewed was the background check, and Mr. Silva granted permission to have the criminal history publicly presented. and discussed. Sheriff DiBasilio explained that the appellant's background check disclosed the appellant was convicted of possession of a Schedule II drug. That was a felony conviction, and that conviction had not been expunged. Mr. Sheriff DiBasilio explained that he believed that conviction was reasonably related to qualifications, responsibilities, and such related to commercial cannabis cultivation. And on that basis, he recommended denial of the appellant's appeal. Mr. Silva testified that he believed there was no relationship between that previous conviction and his duties and responsibilities as a cannabis cultivator. And also explained that it was his understanding that that conviction had been expunged. He had hired an attorney to do so. However, obviously the conviction had remained on his record, and the commission noted that, and that was pretty much the end of the discussion along that reason for denial. In reference to the evidence photos, Mr. Silva explained that the evidence photos were prints of phone snapshots that were taken by a friend, and that the date that was on the phone snapshot was placed on the corresponding photo, the corresponding evidence photo. That friend then gave those photos to Mr. Silva for the purpose of submittal in Silva's application for registration. The commission questioned the April 20th photo showing the cannabis cultivation in the hoop house, and why was that different from what they saw in the Terra Server image of May 1st. Silva explained that they actually had a hoop house on the site. That was a portable hoop house, and that was from the beginning of February 2016 when they first occupied that parcel. Initially, there was no cover on the hoop house. At some point later in time, which he could not remember, a cover was added to the hoop house. Originally, it had been located to the front of the house and was later moved to the side. And that photo of the cannabis, the April 20th photo, was actually taken inside that portable hoop house, not the greenhouses. In regards to the April 15th photo that showed the yellow grass surrounding the porch, behind the porch, and it's and the difference between it and the Terra Server aerial of May 1st with the green grass, a commission member asked Mr. Silva, what is the date that that photograph was actually taken? And again, Mr. Silva explained that the dates were taken off the snapshot on the friend's phone. He explained that some green grass could be seen along the edges of the porch, right in there. There is some green grass there. And also, he held up his phone. He had a phone with him. He held it up, and he stated it showed an image of the porch with green grass and the cannabis on the porch, and it was taken on April 28th, although he didn't show that directly to the commission members or otherwise submitted as evidence. The discussion actually on the photographs end with a commission member asking Mr. Silva whether he could actually explain those photographs. And the statement was, you can't explain those right? And Mr. Silva responded saying yes. Effectively, he couldn't explain them. The next issue was the permit issue. In regards to that, Mr. Silva stated that he had in fact gone in and submitted plans after being told to by code. In that process, it was discovered that he had built the greenhouses over his septic system. And he was told at that time that he would not be allowed, the plans would not be accepted for review until there was a relocation of the septic system designed and approved. And following that information, he had gone ahead and obtained the services of an engineer for that purpose. And the issue with this line of reasoning is that he implies that the only reason he couldn't meet the code deadline to, go and begin the permit process within 10 days was because he couldn't submit his plans. He had built his greenhouses over the septic system, and the county would not take his plans. But actually, that is not the issue here. The issue is whether he had, in fact, begun building, began construction on structures that required a building permit prior to beginning construction, and that was the case. And that was the reason for denial. That was a violation of our local laws, and that is why his registration had been invalidated. The commission, without stating any specific observations as to each individual reason for denial, and without any objections to any of those reasons for denial, agreed with the findings within the resolution and voted to deny the appeal 5-0. And that was what occurred at the commission hearing. If you guys have any questions, I'd be glad to answer them.
Yes, if you go back to the pictures, the two from April 1st, April 20th, it's in the first couple slides. And it shows the plants in a hoop house. It also shows a lot of disturbed dirt around the plants
Right.
in that hoop house, correct?
Yes, sir.
So the next question would be, if the hoop house was there before May 1st, or taken down before our aerial image was created on TerraServer before May 1st, wouldn't we then somewhere around this property see a brown rectangle of some type on the ground?
That makes sense to me. The only place I think we see that is actually out here, and that's the May 1st area where it appears they have grubbed or scraped the earth to begin preparation for construction of the...
Could it more likely be right in here?
It's a possibility, sure. I would expect it to be up against the house, because I believe that's the structure I'm looking at.
It's just that it isn't consistent to take down a hoop house. If you have one up, why would you take it down?
I can't explain that.
I can't tell you a whole lot of them that do. I mean, what I've seen in my district is they'll take down the covering,
Right,
but the ribs will remain.
right.
So,
He did in fact say he did in fact say it was a portable hoop house. So, I mean, the cover could have been pulled off and he could have moved it. That was the implication of his testimony.
go back to that picture, the other picture again of the TerraServer. What's interesting too here is if he claims that he was growing, what is the distance of setback between his property line and the actual grow area?
I think the
I could
setback-
estimate because I could
Right.
see the size of that dwelling. It's about
Mhm.
about a 30-foot wide dwelling this
Mhm.
way, okay? So
Correct.
he's within about 30 feet of his property line.
I would agree with you.
And that the hoop house was in the property, in the 75-foot setback as well. Okay? So then we have the code violations, and we never did get the permits issued?
No, there was not even an application submitted, to the best of my knowledge. The only, a check through environmental health and the building department, the only type of permit activity that's occurred is a permit for some profile holes.
Okay,
Yes.
so he never did receive any permits to correct his septic violations? The building a structure over the top of a septic tank?
No, sir, not to the best of my knowledge. His testimony was that he had hired an engineer to undertake that work, to begin the design, redesign, or design of the relocation of the septic system. And
But there was no actual permits issued to actually do the work
no, sir.
necessary to correct the fact that we've got a building sitting over the top of this. Now the next question is, that septic is still active today.
To the best of my knowledge,
And that being said, is someone living in that dwelling?
I can't answer that
With-
question. I have no direct knowledge.
Okay. With an illegal structure sitting over the top of a septic system. Okay.
Could very well be.
I'm just trying to wrap my head around all the things that are going on here. All right, that's all I have for now. Thank you.
Very good.
Other questions? All right, we'll have a presentation by the appellant. Is the appellant here? Mr. Silva? Seeing none. Presentation by members of the public. Anybody want to speak on this one? Seeing none. Summation and rebuttal by appellant. Not here. So we'll move on to staff summation and rebuttal to the appellant. Didn't exist.
I don't believe there's any.
Okay, public comment?
I just have one question. Being an old IT person, why can't you obtain the metadata for these photographs and post it? That would give you total clarification of when that photo was taken in a digital image, and there would never be any question whatsoever. If I said that was May 1st, 2016 in the metadata, it's right there. And why it's not presented in your reports, I don't know. It's not that tough, I tell you. Thank you.
Are there public comments? Seeing none. More questions from the board? Seeing none. Close this appeal hearing. Go to board discussion deliberation. Any discussion? Okay.
Mr. Chair, I would move to uphold the Planning Commission denial of this appeal.
Motion.
I would second that.
Motion by Supervisor Tovenelli, seconded by Supervisor Clapp. All in favor?
Aye.
Opposed? Resolution's upheld. Number 3?
Item 30 is from the Planning Department to conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-534 for BLB Collaborative Farms at 5938 Southworth Road, Valley Springs, APN 048-025-105.
Open this hearing. Staff presentation.
Yes, this is appeal number 2016-534. Mr. Matthew Clark, on behalf of BLB Collaborative Farms, Farrington Thomas President, is appealing a denial of a commercial cannabis registration by the Planning Commission. The reason for denial by the Planning Commission was the registrant failed to obtain a business license application by the September 7th, 2016 deadline. Site location, it is 5.12 acres at 5938 Southworth Road in Valley Springs. That's within Section 32, Township 4 North, Range 10 East. And you can see on the screen up there the red rectangle on Southward Road. You head on up and you go on up Burson Road. It's about, I believe, about 1.5 miles or 2 miles up to the intersection at Highway 12, and then it's about 3 or 4 miles out this direction to Highway 26. On June 28, 2016, BLB Farms Collaborative Farms, Farrington Thomas President, filed a commercial cannabis cultivation registration application for 22,000 square feet of mixed light cultivation area, and they were granted a registration pending application for that amount and that use. Section 1795-165 N5A requires applicants to submit a business license application by September 7th, 2016. The applicant failed to provide the planning department with that application, and therefore the registration was denied. There also was a denial based upon a sheriff's recommendation for denial, but that was subsequently withdrawn after further investigation. On March 13, 2017, Mr. Clark submitted an appeal on behalf of BLB Collaborative Farms, Farrington Thomas President, for consideration by the Planning Commission. In the letter of appeal, Mr. Clark stated that the appellant Thomas obtained a BLA and brought it to the Planning Department prior to September 7, 2016. At the Planning Department, Thomas was unable to obtain a copy because the copier in the Planning Department was broken. He also observed that both the tax collector and the Planning Department do not keep records of persons obtaining a business license application. He also pointed to a purported lack of record keeping and chaos within the Planning Department as reason for waiving the deadline for Thomas's submittal. On June 8th, 2017, the appeal was presented to the Planning Commission. And that began with rebuttal of those appeal letter points by the Planning Department. The claim that Thomas had obtained and brought the business license application to planning prior to September 7th. It was noted that that claim is not date specific. It doesn't say, well, I brought it in August 10th or, July 8th. It was simply sometime, anytime before September 7th. There was the claim that the Planning Department copier was broken. Well, we checked service request records within the Planning Department to see if on or about this time period there was actually a request made for any repairs to the copy machine, and no such request existed. Also, had that actually been the case, copies could have simply been obtained at the building department counter, which is literally 10 steps from the counter in the Planning Department, or he could have gone elsewhere to get a copy. He could have taken a snapshot on his phone. It was simply Mr. Thomas's choice not to obtain a copy of that business license application. To the claim that chaos within the department was the reason for, quote, a lost business license application, we have handled hundreds of these applications. When they come into the Planning Department, they are kept. The paper copy is kept and put in our files, these right here. That paper copy is also scanned and goes into our electronic file, so we should have a couple of records at least of something showing up in our possession as far as his business license application goes. So when in fact one is submitted to us, we document it, it goes into the file, and it itself, its physical self, that business license application becomes the record. To the claim that records are not kept by either the tax collector or the Planning Department of persons picking up a business license application. The business license application is a blank form. Like any form for county business in any department, the public's welcome to come in and pick up a form. There is no obligation, I believe, by any county department to keep a record of people who come in and pick up blank forms. And there is certainly no obligation on the part of the Planning Department to do so. This is way outside our purview. Had that actually happened, I want to go back here. The business license form itself instructs the applicant, when they pick it up, to take that business license application to the assessor's office for approval. Once you go to the assessor's office, the assessor requires you to fill out a business questionnaire prior to putting their stamp of approval on your business license application. That business questionnaire that the assessor asks you to fill out is retained by them. They keep that. That becomes a record. And the assessor does maintain a record of commercial cannabis questionnaires. After receiving the denial, Mr. Thomas did in fact go and pick up a business license application. That was on March 13th. That is what you see on the left side of the screen there. He picked that up and he followed the instructions on the form that tells him that he needs to go see the departments listed below in the order in which they're listed, the first being the assessor's office. And that's what he did on March 13th. He walked down to the assessor's office where he was asked to fill out the business questionnaire, which is the document to the right of the screen up there. He filled that out and the assessor kept that document. He then came to our office and submitted the business license application to the planning department. We have that, it's in our records right here. In following up on this, on April 24th, I went over to the assessor's office and made inquiries about this process. While I was there on April 24th, they made a copy, this copy right here, of the questionnaire that Thomas had completed on March 13th. They had still had that in their records and they were able to provide me that. I asked them, well, do you have a record of a business questionnaire prior to September 7th? And they did not have a record of a business questionnaire prior to September 7th. So in fact, had Mr. Thomas actually gone prior to September 7th, obtained the business license application, taken it down to the assessor's office and completed the questionnaire, not only should there be a business license application within our file, there should also be a business questionnaire completed prior to September 7th in the files of the assessor's office. Neither of those are there. At the appeal hearing, there was testimony by the appellant. Thomas stated that he had obtained the business license application about the time he obtained his seller's permit, and that date for the seller's permit proved to be June 9th based upon a snapshot that he had on his phone. Thomas stated that after reviewing his application with his attorney, Mr. Clark, he had submitted the business license application with his application on June 28th, 2016. Prior to doing that, Mr. Thomas did not make a prior of the business license application or the application for registration itself. Mr. Clark stated that when reviewing the application for Mr. Thomas, he had not made any conscious note of the business license application one way or the other because it wasn't really required to be submitted until September 7th of 2016. Mr. Clark also did not make a copy of the application package when he reviewed it. Based upon that testimony, the Planning Commission had a few observations. The first was that the appellant was presenting two different scenarios. In the first, which is consistent with the statements within the appeal letter, he obtains the business license application and goes to planning where the copier is broken and no copy is available. In the second scenario, as presented to the Planning Commission, the business license application is submitted with his registration on June 28, 2016. No trip to the planning department and no broken copier. The Commission also noted that Mr. Clark did not testify that he saw that business license application within the application, the registration application package when he reviewed it. And finally, the appellant did not follow the business license application instructions, visiting the assessor's office first and filling out a business questionnaire. This would show a business license application was obtained and taken to the assessor's office, if not in fact submitted to the planning department. Mr. Clark had presented a brief the day before for the Planning Commission's review. A couple of things he verbally discussed from his brief was that the acceptance of the business license application in lieu of an actual business license is an inversion of normal county business practice. The other issue being county staff and judicial officers cannot be neutral on issues related to cannabis cultivation. Those opinions were strongly rebuffed by the Planning Commission. Mr. Clark also, during the meeting, presented an example of what he termed a lost business license application from a different cannabis project, that being O'Leary, Project 2016-109. There was no discussion by the Commission on that item. And also the point of loss of a registration, loss of a registration was an excessive fine for non-compliance with the September 7th, 2017 deadline. That was also not addressed by the Commission. Commission, their finding was based on section 1795-165 N5A, which requires that the applicant obtain and submit proof of a business license to the Planning Department by September 7th, 2016. The Commission found a business license application was not received by the Planning Department by September 7th, 2016, and the subsequently, the registrant did provide a business license application dated March 13, 2017 that does not meet the September 7, 2016 deadline. And on that basis, the Commission voted 4-1 to deny the appeal.
Any questions for staff and board?
Thank you. Could you explain the process again that we go through in accepting documents, period, throughout our various departments? I guess more along the lines of when a document is placed into our possession, what process do we use to confirm that we actually have received that document?
Well, it's going to vary a lot, between departments and depending what document it is. If we have an application that requires a fee, they'll be provided a receipt for submitting that fee. We don't typically make copies of the documents unless the applicant requests a copy of it. When it's received, it goes immediately into the file with the cannabis cultivation documents. We also, Mr. Groh pointed out, we scan them, so we have an electronic copy of that as well. So that's the practice of the Planning Department. I assume that it is similar to other departments, but I can't speak for them.
Do you not date stamp each document when it is received?
Yes, we do.
With the date that you received it?
That's correct. We have a stamp at the front counter, and the stamp you saw that on some of the documents. Typically, it's a red stamp. You can see there in the upper corner of the...
Right. So going back to a previous comment about photographs, it is very easy if you're not wanting a record. Every phone has a capability of making a photograph for a document to prove receipt, correct?
Yes, correct.
I can't think of a phone today outside of flip phones that might not do that. Okay. So that being said, picking up an application by itself isn't equivalent to the submittal of a completed form.
That's correct.
Okay. And there's no questionnaire on this application within the date range necessary to meet the September 7th date?
None that we could find.
I'm going to jump to is the attorney of record, Mr. Clark? Is that correct? Thank you. And I guess I'll reserve my questions until the appellant has had an opportunity to speak. Thank you.
When you pick up a business license application and you submit it, are you required to pay the fee at that time for a business license?
The fee is paid after it's been signed off by the other required departments. The required departments are the assessor, planning, and building. In some instances, also the sheriff's office. Once those have all been signed off, you take it back to the treasurer tax collector, and the fee is paid at that time.
Thank you. There doesn't seem to be any other questions for the staff. Presentation by the appellant. Mr. Clark.
Thank you. Yes, members of the board, Mr. Vice Chairman, county staff, thank you for this opportunity to speak. My name is Matthew Clark, and I'm here to represent BLB Collaborative Farms in this issue. Mr. Groh, if you would please, can you go back to the basis of denial? It was one of your first slides. Yes, it says right there that 1795.165N5A requires applicants to submit a business license application by September 7th, 2016. That section doesn't say that at all. That section says that a registrant with a pending application for registration by September 7th shall provide verifiable documentation to the planning department demonstrating that the registrant has completed all of the following tasks. And then A, receipt of a current valid business license pursuant to Chapter 5.04. It doesn't say anything about filling out the application. It says that you will have the business license by then, or verifiable documentation that you have the business license by then. Now, I agree with county staff that when you get a business license, there's an abundance of documentation. However, when you get a business license application, there's not. And furthermore, testimony from the previous hearing showed from county staff that the tax collector did not go through in every case their normal procedures of sending these things off to the other departments, but rather handed the completed application, stamped it, and handed it back to the applicant for the applicant to take it themselves over to the planning department. There's no other record. It's just a form. It's just an application to be filled in. And for the county to now stand here and say that they didn't lose any of those, well, I can't understand that. Especially when I noticed that we didn't see the slide of Mr. O'Leary's business license application. Now, Mr. O'Leary had the presence of mind to take a picture of his business license application, which the county did subsequently lose. He, fortunately enough, was able to bring the picture in and show that he, in fact, had turned one in. And that application is in evidence. I don't know if you've been able to see it. I have a copy here, but it's part of the appeal packet that was on the website. This case is not complicated. I know you've seen probably a lot of really bad grows, disappearing hoop houses, all sorts of horrible things, but there's none of those here. This was an excellent grow. It did everything correctly, and the only thing that was missing was a business license application, which again, I'd like to point out that my client stood here at this very stand and testified that he did, in fact, turn it in. It's a his word against yours issue. And I don't understand why it's come down to not believing him when there's so much evidence that this whole thing was, in fact, inverted. This process was chaotic at the time. And what you're looking at doing now is denying my client $5,000 of his registration fee, tens of thousands of dollars of infrastructure improvements on his property, an entire year with the hard work that you know is what he must have put in order to have gotten through the rigorous application process that we have here. And there's no problems on the site. There's no pesticides open. There's no dumping of waste. There's no guns. There's no criminal activity. This was a perfectly good, perfectly clean grow site. As I've thought about it in the subsequent weeks since the past hearing, I think over and over again, Mr. Groh mentioned it, the excessive fine argument. The county code provides a penalty for operating a grow, or for operating a business without a license. That penalty is $500. What we have here is a person that was operating perhaps without a business license, even though everyone was operating without a business license. 0 business licenses had been issued by September 7th, 2017. 0. Right? And so here's someone operating their business without a license, and instead of $500, we're looking at $5,000, plus tens of thousands of dollars worth the effort, plus an entire season's worth the effort, years since June 30th, when he submitted his application, along with his check. This is not one of the bad grows that we're looking to get out of our county. This is a guy that swears on a stack of Bibles that he brought that in. I don't know what else to say about this. It's such a simple issue. There's no photographs. There's no complicated legal issue here. It's just a he said, she said sort of thing. And I don't understand why we can't just give Mr. Farrington and BLB collaborations or collaborative farms the opportunity, as they tried to do with their business license that they brought in, which, by the way, he came and asked me about that March 13th business license application. And I told him, I don't see why it would hurt. Go ahead and try to submit another one again. Obviously it's being used against him now. I think that's too bad. But I don't know what else to say about this. I don't know what else to say. I think that you should take the opportunity now to take a perfectly good grow. And I think that you should look at the fact that that we have evidence that the county has lost these forms before. We've seen that the county is not following its own rules in mandating business licenses. I'd like to point out that since the past hearing, the county has issued letters to people that haven't had their business licenses approved yet, asking them all to come in immediately to finish the process. I think that what you ought to do is recognize that mistakes were made, things were lost. This was a fast-acting process. It was a chaotic thing going on there. And what we have here now is a grower and a company that managed to get through everything and do their site beautifully. And they should be allowed to continue. Thank you.
Thank you very much, Mr. Clark. We'll have public comment. Is there anybody who wants to speak to this?
You bet, gentlemen. Right there. Go to the last slide, please, if you wouldn't mind. You see what that one says? It says application. Get down to the reason for the end of the very last slide you had up there. Nope, last one. The very last one in the whole thing, where you say, you give that same quote. There it is. That's the one that's in the ordinance, folks. And it doesn't say anything about an application. It says applicant must obtain proof of a business license to the planning department by September 7th. We didn't have one. Not one grower in this program had a business license by September 7th. You're rejecting somebody for a piece of paper, an application that wasn't put in. Any other business, if you have a business for a winery, if you have a business for a grocery store, a car repair, and you run that business for 1.5 years, 2.5 years, 5.5 years, 6.5 years in this county, it's a $500 fine. But you're going to reject somebody because they didn't have an application for that business license in by September 7th. It's ridiculous. And you have planning misquoting the statutes. Look, it says same number. as the one before. Go back to the basic. Show that one. How come you change them? How come you can change the words, but people can't get a break?
Other public comment?
Bill McManus. First of all, I think the application and the business license are kind of just the same process. As you get an application before you get a business license. You don't get a business license without submitting an application. So I think that's kind of where that issue teeters at. Hey, he's right. This is a really easy one. Today we've already seen an assault on the covenants of subdivisions. We'll just change zoning within subdivisions, which never been done before. And we shouldn't concern ourselves with how many harvests this guy's had since he submitted his application, probably one or two, still growing, still harvesting. You know, kind of a deal for one application fee of $5,000, but no one's going to stop him doing that either. This is really easy to approve. It really is. You guys, it's a piece of cake. All you have to do is ignore the laws and ignore the ordinances. And then you can do whatever you want. It's a piece of cake. Otherwise, you might have to look at the laws and ordinances and say, do they apply? Were they put in force for a reason? Does everyone else have to follow these laws and ordinances? As a general contractor, I didn't get away with saying, I'm going to. Only in Oklahoma can you get away with saying, I'm fixing to do something. That means you're going to do it sometime. That's okay. We're not in Oklahoma. Everyone else that I know, every businessman, every contractor, every tradesman has to follow the ordinances and the laws to the letter. There is no slop. There is no second chance. You either do it right or you don't do it. So anyway, I just wanted to tell you that looks pretty straightforward to me, but maybe on the other side of the podium it looks a little bit different. So thank you.
So no other public comment that I'm seeing here. We will move to a summation and rebuttal by the appellant. Mr. Clark, do you have anything else?
I mean, I suppose I'd like to address something Mr. McManus said, which is, ignore the law. Right? He said that we can go ahead and ignore the law. I'd like to just point out that the urgency ordinance has a lot of points. It has a lot of things that you have to do. Right? The inspections were rigorous. And he passed. He did not ignore the law. And as for the number of harvests brought in, I have pictures on my phone right now. BLB Collaborative Farms abated in response to their denial.
Is it, can I ask a question?
Okay, I think we're going to come back to questions.
Yeah.
We'll come back to questions. Got strict rules that I'm supposed to follow here. Staff rebuttal, summation.
I'd like to clarify the issue of the application versus the approved business license. When the urgency ordinance was adopted in May, there was a belief that we were going to have about 200 applications. We could process them during the summer, and that by the end of the process, the September 7th date was established as reasonable time frame to complete all the rest of the paperwork that was going to be necessary to get a business license, a water board permit, a seller's permit. As we were, almost a fourfold increase over what we expected. The workload was a lot greater than we expected. The time frame necessary to process all that, even just to put the packages together, establish the files, took quite a bit of time. We realized we were not going to have any issued prior to that deadline, and so we made a decision to accept the business license application in lieu of the actual permit. We did not want to issue a permit before we actually approved the registration. So there wouldn't be an argument that, aha, I have a business license, that gives me a right to proceed when we might end up denying their application. Subsequently, in the last month or so, we came to a situation where a state agency was requiring a business license in order to issue a permit necessary. And since the growers operating under a application pending status of their applications are operating a business in the county, legally operating because we have not completed our review of their application, so they're allowed to continue to grow under the application pending status. They legally are operating under the terms of the urgency ordinance until final action is taken either to issue the registration or deny it. And so we have subsequently notified all of the registrants that you do need to get their business license now. We need to finish the process of issuing the business license. So the confusion about the summarization of the code that says you're required to have a business license application submitted was our response to the timing and as a means to satisfy that requirement so that the applicant did what they needed to do, go to the tax collector, take the application, and submit it to our office. We would then finish processing it once the registration review process was done. The difference between that and the O'Leary situation was that Mr. O'Leary did have documentation to show that he did submit it to us. I can't say that we categorically did not lose any document during the process. We were as careful as we possibly could throughout that process.
Peter, just a point of order. Point of order. Was the O'Leary issue brought up during the Planning Commission?
Yes, it was.
Okay, just wanted to confirm. Thank you.
And so he provided documentation to show that he did submit it. It's like trying to prove a negative, that we lost something that we don't have. There is no documentation to show we had it or did not have it. So yes, in a way it is his word versus ours. But we don't have any record of it. There's nothing to show that he did submit it to us. And I just, that's where we're at. Our records show no application was submitted for a business license to our department prior to September 7th. And unless there's some other documentation to show otherwise, that's what we have to go on.
Another opportunity for public comment.
Sam Cook. It seems like in a matter with all the forms and everything else, if you're trying a new industry in a new area, in any new businessman, I would assume, would be smart enough to get a receipt or an acknowledgement or a copy of a critical document when you're applying for something. I would if I was opening a business or I was applying for a business license. Walk in, I want a copy of that or at least a receipt of that and an acknowledgement of date and time I submitted it. Now, as far as the $5,000 loss, I'm sure they've had at least one crop. I understand, I'm not a cannabis grower, but I understand they get 3 harvests per year. So I think his $5,000 is kind of covered and is a moot point. But I think his activity as a businessman, if he didn't get a copy of that submitted license, is pretty poor.
Other public comment?
Al Segala. The question I have is if he paid for the business license, he might have something in his check register indicating that he did, and that probably should be submitted if that's the only evidence he has. So if the county got the money, there must be some way of tracking that, and perhaps that's where our solution is.
afternoon. My name's Steve Snowden. And regarding business licenses, excuse me, this is one of the stranger counties in that you have to have a county business license to have the City of Angels business license, and which I found out as a roofing contractor for 40 years up here, between here and Bay. And this appeal appears to me that it's a violation, and if nobody else had one on September 7th, necessarily, I don't know when they did get them, but if that's the only point that the man was in denial, then we ought to think about that. And why didn't everybody get denied? Thank you.
All right, we'll close public comment. Board questions. Gary?
What kind of grow is this? What size and what type?
It's 22,000 square feet of mixed light 22,000 square feet of mixed light cultivation area.
Mixed.
Mixed, yes, sir.
So have you been to this property?
Personally,
There's no aerial photos or anything of this property whatsoever in this package like the previous one.
We did not provide any of that because that was not the basis of the denial. The sole basis of the denial was the lack of the business license.
Does this property have a very large red barn on it?
I believe it might. I think from memory here. Again, no one from our office has actually been out there.
It does have a very large red barn on it and an overcrop coming out from the barn.
There is actually a large pole barn on this property with what appears to be a red
Awning type.
outside. Well,
going
there's a
up.
red structure behind it of some sort of big, large shed.
The applicant has stated that they've completely abated now. There's no growth going on now.
Photos I have. No, that's the photos I have, yes.
There's nothing being grown indoors.
And code enforcement has verified that it has been abated.
It's been what?
It's been abated.
It's
Code
been
enforcement
abated
verified.
from on the outside. Did they go inside this big red barn?
They did not go inside.
Okay.
I also know, however, that Mr. Thomas left to go back to Texas about a month ago. And yeah, if he's growing anything in there, it's probably dying.
Yeah, I drive by this property quite often, so I'm familiar with it. I know exactly where it's at.
I'm afraid I'm not as familiar.
And there's a new fence that has been built in front just not too long ago, within the last couple months. That it looks like it's shielding something. That fence was not there a couple months ago. So I don't know who's on the property or what's going on the property, but somebody's there on that property.
My client isn't, that I'm aware of.
As far as building permits, thank you so much for as far as building permits go, it's not building permits, excuse me, business license go, I wish it was this easy for me to just merely fill out an application and be able to do a job, because every place that I go, every city or county that I do a job in, we're required before we even go into the county or the city to put any steel up or any construction at all, to have a business license issued from either the city or the county before we can even step foot in to do a job in any of those places. So this is very lenient, and believe me, being a businessman, when we fill out applications for anything or we do anything, we document it. So we have documentation in case something like this comes up. And it's came up a couple of times, and we provided the documentation. To merely fill out an application and walk it over or whatever happened and not take the time to get copies of it for your own personal records. I don't know the way the process was explained here for this application. You need to go and get it approved by several departments. So you would have to have access to that, and you would keep a copy of it just for your business records. I mean, in case something came up later on. So I'm a little bit confused on being asked to excuse something based on the county losing something when basic business tells you that you need to be able to document everything that you're doing. And if he did turn in, he never finished the process to get a license. He never took the application around to have each department approve it, so he could pay the fee to get his license, because ultimately you were going to need a license, and you had to show you were in process of getting the license prior to September 7th. So those are my comments.
Yes, I'm in talking in the same mode because I also did some contracting work. In fact, my bookkeeper's in the audience, and she can tell you that every time that I went into a different county, city, municipality, that's the first thing we did. We went and found a business license because you just don't conduct business without it. It's just the way it's done. I feel that the burden of proof here, it really, it comes down to if we made a payment on this thing, we should have some kind of receipt from somewhere within our system to show that a receipt was given out, correct?
Yes, but no payment was required until the very end of the process when the business license was issued. At the time that this was denied, we hadn't issued the business license yet because we hadn't finished processing the application.
However, what we're talking about, though, is still the application itself. We never received it. We have no record of receiving it. So therefore, we've got nothing to work with.
That's correct.
So my question then to Mr. Clark, regarding it being the attorney of record here, correct, sir? Is how long have you been the attorney of record for this appellant? How long have you been as attorney?
I would have to look at the retainer agreement in particular, but
would it go back into
but it would have been
June
through
of last,
May.
June of last year?
It would have been during the 2016 registration period.
So it sounds as though he was bringing paperwork to you and having it looked over and confirmed that this is things I need to do?
Yes, but not the business license. The business
not the
license
business.
application and the seller's permit occurred later on September 7th and were not part of the document review during the registration period.
But you did do a document review on all of the other documents that he was to submit?
We would have had a checklist for, everything else, yes.
Okay.
But it would have never have said one way or the other on the business license.
Okay, thank you.
I have a quick question. We have two versions of this code up here. Which one's the correct one? Second one? So we do have, obviously we had no business license issued prior to that.
Yes, no business license was issued.
Prior to September 7th. Well, according to this, we were requiring a business license.
That's correct. That's the way it was written. But due to the exigencies in, say, obtaining a sheriff's, at that time, it was required that the background be done.
Yeah,
That
I
took a
understand how we
matter of
got
time.
behind. I'm just
Yeah,
checking two rules
okay.
and conflicting on our presentation. Thanks. Any other board questions?
I just wanted to clarify for this board, I just wanted to remind you that the burden of proof is with the appellant, not with staff. The burden of proof is with the appellant.
Okay, if there are no further questions from the board, I will close this public hearing and board discussion and deliberation.
Council. It's interesting you stated that because on one of my pages at the top, it says burden of proof is on the appellant. So that is the key point here, is that anytime you are conducting business, it is not anybody else's responsibility to see to it that you are completing all of the requirements of that process. It is on the applicant. So I just don't see that there's any room for us to move beyond the strict statement there in 1759516 and 5A. It says receipt of a current valid business license pursuant to Chapter 5.04 of the Calaveras County Code. That's what it says. I'm reading it. Anything?
I have, sorry that we have things written that way, but we were where we were at this time, and the burden of proof is on the appellant. It's tough. Is there a motion?
I move that we uphold the Planning Commission's denial of this appeal.
Moved by Supervisor Tofinelli. Seconded by Supervisor Clapp. All in favor?
Aye.
Aye. Opposed? Carries.
Item 31 is from the Planning Department to conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-561 for Ray Moore on 6216 Trout Lane, Mountain Ranch, APN 021-010-030.
Appeal hearing is now open. Start with staff presentation.
This is appeal number 2016-561. Patrick Goggin, on behalf of Ray Moore, is appealing a denial of a commercial cannabis registration by the Planning Commission. The reason for denial by the Planning Commission was the registrant failed to submit all necessary forms and documents to the Central Valley Regional Water Quality Control Board to constitute a complete application by September 7th, 2016. Location of the site, it's a 10-acre site, and it's located at 6216 Trout Lane in Mountain Ranch. That's within Section 35 of Township 5 North, Range 13 East. And if you're looking at the map up on the screen, this is the intersection of Mountain Ranch and Sheep Ranch Road. I think pretty much everybody's familiar with that. It's a couple of miles back down into the town of Mountain Ranch. But if you turn north and head up Mountain Ranch Road, we shortly come to Trout Lane, and the parcel is located right there. On June 28, 2016, Ray Moore, and Ray Moore is the applicant. Ray Moore is the registrant of record. Ray Moore filed a commercial cannabis cultivation registration application for 22,000 square feet of outdoor cultivation area, and that was later amended to 17,500 square feet. The reason for denial, again, was failure to comply with the requirements of the Water Quality Board, submittal of the registrant's NOI and $10,000 annual fee by the September 7th, 2016 deadline. Mr. Moore did, on June 28, 2016, submit his notice of intent and the $10,000 annual fee. That payment was with a post-dated check. Okay. Evidently, the Water Quality Board didn't catch that. It looks like they pretty much immediately went and deposited the check. There were insufficient funds. And the Water Quality Control Board then sent Mr. Moore a dishonored check notice on July 7th, 2016. After that date, And up until September 7th, Mr. Moore, as the individual, as the registrant of record, did not resubmit his annual fee to the Water Quality Control Board. However, on September 7th, 2016, Ladybug Farms, LLC, did submit a notice of intent on this project, along with a valid annual fee. Now, it's not unusual to amend a registration application within our office from an individual to a corporate entity. To do that, we require a few things. First of all, we require a letter from that registrant. We require that letter to state that the registrant requests that the registration be amended from them as the sole registration into that corporate structure. The other thing that we normally require is an operating agreement. We want to see an operating agreement and know that that registrant is still, in a majority within that corporation. And also we want to know who else is a member of that corporation, because we're going to want a background check by the sheriff on those people. We never received that documentation from Mr. Moore. And the last thing that we require is, of course, an indemnity for the county under the corporate name. And again, that wasn't provided. So those three legal obligations weren't met by Mr. Moore in terms of changing his registration as a sole proprietor into this corporate entity. About 5 months after that September 7th deadline, towards the end of February 2017, Ladybug Farms withdrew their notice of intent and their application from the Water Quality Control Board. The Water Quality Control Board then issued a notice of non-eligibility to Ladybug Farms on March 2nd, 2017. Moore, not having resubmitted his annual fee to cover his submittal as the sole proprietor, his registration, at that point had an incomplete application when Ladybug withdrew theirs. Because of that, Moore had not met the requirement to have a complete application in place by September 2nd, 2016, and his registration was denied. Subsequent to his denial on March 20th, 2017, Moore submitted an appeal to the Planning Commission and then obtained the services of his attorney, Mr. Patrick Goggin, who at the Planning Commission hearing of April 27th requested and was granted a continuance of the appeal to May 25th. On May 25th, the appeal was presented to the Planning Commission with Mr. Goggin representing the appellant. Mr. Goggin testified that in the time since the denial and the appeal hearing, Mr. Moore had gone ahead and resubmitted his annual fee, along with a site management plan that had subsequently been required by the Water Quality Control Board on his project. And as of that time, as of the Planning Commission date, Mr. Moore was in good standing with the Water Quality Control Board as far as the application fee, his NOI, the site management plan. They were happy with him. In that in-between period, Mr. Moore had also formed a new corporation, and that I believe was called Phoenix Gardens. And under that corporation had obtained a new state seller's permit and a business license application. Citing abuse, sabotage, coercion, and battery by Petkovich, who was going to be one of the members of Ladybug Farms, and the breakup of the Ladybug Farms as mitigating factors, Mr. Goggin requested that the Commission recognize more subsequent efforts as constructive compliance relating back to that September 7th deadline. He He also explained that, yes, Mr. Moore's check was post-dated to September 7th, 2016, and it had been returned when the Water Quality Control Board attempted to cash it earlier. He stated, he also testified that, yes, Ladybug Farms did submit an NOI, an annual fee, on September 7th, 2017. His contention was that the reason for the denial of Mr. Moore's application is a retaliatory withdrawal of the annual fee by Ladybug Farms. The commission explained that their understanding for the reason of denial is that it was Moore's failure to resubmit his annual fee prior to the September 7th, 2016 deadline. Mr. Goggin further explained that in Mr. Moore's mind, he was part of Ladybug Farms LLC, a corporation that had not yet been formed in that summer of 2016. At that time, Moore, Michael Petkovich, and other partners within Ladybug Farms were working together with the understanding that that corporate entity would be formed and they would all participate within it. There was a verbal agreement among the partners, though Moore was not given an operating agreement to sign. With that in mind, the Ladybug Farms submittal of September 7th, 2016 should be, he argued, should have been accepted as a submittal by Moore, allowing Moore's resubmittal as constructive compliance. That testimony, those ideas were rebutted by Romina Filipponi, Michael Petkovich, who were going to be two members of Ladybug Farms, along with their attorney, Peter Carolus. They stated that Moore was given the opportunity to review and sign that operating agreement, and that Ladybug Farms LLC had actually incorporated in August of 2016. The reason that the Ladybug Farms submitted a separate NOI and annual fee to the Water Quality Board was because it was the intent of those partners to form that corporation, to execute the operating agreement, and operate that cannabis enterprise under the name of Ladybug Farms. And that was the reason the Ladybug Farms NOI and fee was submitted in their name and not Mr. Moore's. The commission, after hearing the testimony, made a vote, and that was in consideration of Section 1795, 165N4, which requires the registrant to submit to the Water Quality Control Board all necessary forms and documents to constitute a complete application for that agency's purposes no later than September 7th, 2016. The commission found that Mr. Moore was the sole applicant and solely responsible for providing his annual fee to the Water Quality Control Board prior to the September 7th, 2016 deadline. To support that, they observed that there were two separate annual fees and two separate NOIs by two completely different entities that were submitted to the Water Quality Board. The fee from Ladybug Farms was returned when Ladybug Farms requested that be done. And also, and this is pretty important, there was no prescription within the urgency ordinance giving the commission authority to accept a fee months after the deadline and make it refer back to that September 7th deadline, the actual true deadline. And with a vote of 5-0, the commission voted to deny the appeal.
Thank you. Are there any questions from the board?
I'm trying to wrap my head around this.
I know, it does take some doing.
Okay, so what we have is we have Mr. Moore as the applicant. Then somewhere along the line, we have a Ladybug's Farm LLC come into the picture. Was Mr. Moore ever a part of that?
No,
In
sir.
terms of a legally
Not-
filed
not-
LLC.
There-
So not a part of it. So how do they take over this application when they're not one of the original applicants, and there's only one, am I correct?
Yes, that's correct.
Should have been part of whatever this process is going down to the very end of the food chain.
Right.
Am I correct here?
Yeah, you should
Okay.
have been a part of it.
All right.
It was the intent of these partners to form that LLC and operate together. That was the original understanding. There was friction that developed within this partnership, and they basically all went separate ways, and when that happened, the whole thing fell apart. The operating agreement was never executed, okay? So we don't have this thing, an operating agreement actually forming and assigning, specific roles and shares and such to each individual entity.
So how would Ladybug Farms have qualified as a successor to that application?
If they fulfilled those three items that I
That
just-
would have created that,
yes, they could have made that conversion. But this has happened. It does happen. But you
Right.
have to go through those steps.
but what you're saying in your summation here is those steps were never completed.
That's correct.
Okay,
So yes, that's correct.
all right, thank you.
If I could add to that, the finding of the commission, though, is even if that had happened, the end result was both entities either did not meet the deadline because they did not have funds to pay the fee, or they withdrew their application. So regardless of what happened, the bottom line was there was not a complete filing with the water board for the notice of intent. And that did not satisfy the requirement of code.
And that's a separate section of questions above and beyond the relationship with Mr. Moore and Ladybug. Is the water board, the application process, who has been involved, withdrawn, whatever happened there. Okay. Thank you.
All right, presentation by the appellant. Mr. Goggins?
Good afternoon, Vice Chair, members of the board, Patrick Goggin on behalf of Mr. Moore. I do think that was a fairly good summary, but there are a couple of points that I would like to add. I submitted with a submission last week an Exhibit H, and that was a document that was submitted along with other documents that Peter Caloris submitted. Do you guys not have that, a copy of that? I'll provide you with it. I had submitted that to the clerk and asked that be distributed.
Oh, okay.
Do you?
Wait, point of order. Counsel, is this new information?
I believe that this may be the brief that was submitted to the board clerk that was distributed to the board and to planning. It was my understanding that that brief was something that was already submitted and part of the record at the Planning Commission hearing.
Oh, and I submitted an additional letter with a couple additional exhibits.
To support this appeal.
Yes, I just want to be sure that this is information that the Planning Commission had heard and that we're not hearing new information.
No, this document was actually a part of the record,
Thank you.
and I'm highlighting it on appeal.
Okay, thank you.
And that document, do you guys have what I submitted? It would probably be helpful. But it was a document submitted by Mr. Petkovich's attorney, the attorney that formed Ladybug Farms, that specifically connected Ray Moore as the original registrant with Ladybug Farms. So there is documentation showing and linking the intention of the parties to proceed with the original registration under Mr. Moore's name with Ladybug Farms by that deadline. But I'd like to take just a step back to also provide some context for the situation, some human relevance here. Mr. Moore is a Cuban immigrant, and he comes from a past of some physical abuse and neglect. And he moved to California from Florida in 2010 to really start anew. And last year, in 2016, he had known Mr. Petkovich from Florida. They were working together to submit the registration and working together in this partnership that ultimately, subsequent to September 7th, went sour. Mr. Petkovich proved to be a controlling individual who was dictating to Mr. Moore the terms of everything. In fact, he went to the property that was leased in Ray Moore's name and pressured him to reassign the lease into Ladybug Farm's name, and without understanding the terms of the operating agreement and the percentages, which kept dropping and changing for Mr. Petkovich, Mr. Moore refused. This property's leased in my name. I'm not going to change it unless we get into some formal agreement that represents the terms that we agreed on originally. Subsequent to that, in December, Mr. Petkovich continued to try to pressure Mr. Moore and physically assaulted him, resulting in charges filed by the district attorney and a restraining order today that we have. In addition, there were texts that were submitted by Mr. Petkovich that were fraudulently indicated that they were made by Mr. Moore. So what we have is somebody on their side who's incredible. And what Mr. Moore was trying to do and did try to do was salvage this whole thing. It wasn't his fault that he was being manipulated and coerced and pressured and abused, and ultimately a victim of sabotage. And he did everything in his power to attempt to remedy all this. So I asked the board, just as we asked the Planning Commission, in addition to looking at this document, understanding that the intention here was to transfer this to the corporation, and subsequent to all of this abuse and injustice by Mr. Petkovich, that Mr. Moore did everything in his power to timely go and resolve these issues, and in fact was successful in complying, albeit after the fact. But when you have a situation such as this, equity demands that there be some fairness and some understanding of the process. I understand the politics in this county and what's going on with cannabis cultivation, but we don't have any complaints here by neighbors, as we have had in other matters. What we're looking for is a little bit of understanding, a little bit of compassion and sympathy for someone who has been a victim of abuse. Thank you.
Public comment? Seeing no public comment. Summation or rebuttal by the appellant. Mr. Coggins, anything else to add?
Not at this point.
Staff summation or rebuttal?
We have no argument that there was an intent on the partners to organize Ladybug Farms. That just simply did not happen. At the commission hearing, the commission noted that much of what Mr. Goggin has just described was more related to a civil matter than anything having to do with cannabis registration and the urgency ordinance and the requirements of the ordinance. None of that really puts a NOI and an annual fee at the Water Quality Board on September 7th. It's just not there. And again, there was no authority within that urgency ordinance given to the Planning Commission to accept a fee or the amends that the appellant had made and make that refer back to make it equal to meeting that September 7th deadline.
Public comment again? You're welcome to come and speak in public comment if you like. You'll be limited to 3 minutes out.
Yeah, it'll be short. Patrick Goggin on behalf of Mr. Moore. I would just like to point out, that's not a civil matter. It's a criminal matter. We have charges filed by the district attorney against Mr. Petkovich for assaulting and battering Mr. Moore. That's criminal. And there's been a restraining order placed against him. Thank you.
All right. Board questions? Board?
So the bottom line is, for the water board application, no one met the timeline. No one met the required date, no matter who it is, whether it be Ladybug Farms or Mr. Moore, or whatever. No one met that, correct?
Well, Ladybug Farms met that, but then they subsequently withdrew their application. And
Okay.
that triggered our finding that they were not in compliance.
Okay.
All right, no further questions from the board. I will close the hearing. Board discussion and deliberation. Any discussion?
I don't have any discussion. I think it's pretty clear cut.
Yes, I have to state on behalf of the attorney that I understand the civil/criminal matter here, but we're not the judges of record for that. This has to do with the hearing regarding cannabis. So I apologize for the disruption in everyone's lives, but it isn't something that we can rule on, unfortunately. Regarding the, who's in charge kind of thing that's going on here, there was supplemental information that was missing. I'm looking at staff because they didn't complete certain pieces of the requirement on time. I think that one of the things that really could have saved this particular relationship would have been if there would have been a way for Ladybug to qualify as, to take over the application, so to speak, but keep Mr. Moore in it. That would have kept it going. As long as the water board requirements had been met, we probably wouldn't even be talking about this today. So it's unfortunate, but we still have these very strict guidelines that this board, as they're sitting here today, didn't create. And we're here to apply the rules that were set in place.
I'm sorry about Mr. Moore's past, and we've all had business deals gone bad. Maybe not everybody, but most of us who are in business have business deals that go bad on occasion, and I'm sympathetic, but what we're ruling on here today is a very narrow thing. Did we meet the letter of the application? And we did not. There's other items, while sympathetic, they're not within our purview. So that's all I've got for the discussion. Is there any further discussion, or is there a motion?
I would move to deny.
Or to uphold? Uphold the planning commission. Motion made by Supervisor Mills to uphold the planning commission's denial.
Second.
Second by Supervisor Tofinelli. All in favor?
Aye.
Opposed? Passes unanimous. Item number 32. Oh, excuse me. We're going to give everybody a 10-minute break. Let's get back here at 3:30. Sound good? Thank you. Federal law.
Item 32 is from the Planning Department to conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's rejection of a commercial cannabis registration for Steve and Renee Snowden on APN 068-003-079, file 2017-046.
Thank you very much. Welcome, Madeline. I think this is your first presentation.
It is.
So, please.
Thank you. Madeline Flandreau, Planner 2. We received a request for continuance from the Law Office of Mr. Kenneth Foley on July 21st, 2017. I believe everyone has a copy of that. It is a request because Mr. Foley cannot be here today. He is representing Mr. and Mrs. Snowden, and it asks to be continued to a date to be determined by the board.
So I guess that's to be considered by the board. Is there any discussion or interest in the continuance?
I know that the appellant is here, and you might want to open up the discussion on the request for the continuance first, and hear from them, hear from anyone else in the public, make a decision on that request, and then either continue it or open up the hearing itself.
Okay. Is the appellant here? Tell us about we're focusing on the continuance request. We haven't opened the hearing yet, so. We're going to take 3 minutes here. Our first question to the board is, do we want to issue a continuance based upon the non-attendance of Mr. Bull?
Before we make any decision on this, I'll be recusing myself from this hearing here.
The entire hearing or
Just
question?
this hearing, because the question would be on with the rest of the hearing.
Do you want to declare
Yeah,
why?
personal friends with Foley.
Okay.
Thank you.
All right, so for the remaining 3 board members, the question is, do we want to continue this hearing to the date that we specify or move forward? Thoughts?
I can still watch it on TV.
Opinion on continuance?
Counsel, we really cannot be asking Mr. Snowden, if he's represented by an attorney, any questions in a hearing.
Correct. If he is represented by counsel, I would caution you to be asking him direct questions. At this point, the issue before the board is whether you feel that there is good cause or not to continue the matter or not. It is certainly within the board's discretion. However, I have not had an opportunity to review the points and authorities for the continuance. It appears that it's just that the attorney is not available today. I know that there have been other situations where the board has considered continuances and whether counsel was available or not as not good cause because there's sufficient time to make arrangements. But that is certainly, considering we now have 3 out of 5, it's certainly within the discretion of this board to grant the continuance for various reasons. Alternatively, if you feel that there is no good cause for continuing it, you can hear the hearing. But I do actually caution the board because Mr. Snowden is represented by counsel. He is not here present. So actually asking him questions, I do caution you doing that without Mr. Foley present.
Yeah, I have no intention of speaking with the appellant directly. I guess the question is the merits of whether or not Mr. Foley's availability is sufficient to cause us to delay the hearing.
When was this scheduled?
When was he noticed to hear it?
Yeah.
It was probably noticed, they were probably advised
Says
within
July.
the last week or 2. You know,
This date of notice, July 14th, 2017.
so 10 days ago.
So we have a date of notice of July 14th, and we get this response from Mr. Foley on the 21st? On the 21st, 7 days later.
Well, he may not have got the notice on the 14th. This is just date of notice, so it could have been a couple of days, and then Mr. Foley is a very busy person.
Yeah, I only stated to just try to establish a timeline. It's not a,
15 days ago.
yeah, it's not an indictment of anyone, it's just to show what the timeline was.
And relative to others, it's relatively short. I'm very hesitant to continue stuff.
But, if I may add, council brought up the fact that there are only 3 members on the board, and to overturn the planning commission's action would require a unanimous vote of the 3 members present. It's not a requirement of the county that a full board be present, or even 4 members, but sometimes the courtesy of having that option. So if one person were to, everyone would have to agree on that, rather than typically a simple majority. So I don't have a problem with the continuance. It certainly is up to you as far as your determination of what you think is appropriate, and the fact that it would be difficult to ask questions directly of the appellant, since he's represented by counsel, probably adds to the benefit to have to continue it at this point in time. So I would tend to agree. I would just soon not continue if we couldn't, if we could move on with things. But given the circumstances today, with Chairman Oliveira out, maybe worthwhile continuing until at least there's 4 members present.
When was this appeal originally denied?
The appeal was filed.
When was the original denial?
This was actually not denied, and I don't want to get too much into it. This was a late request for registration submittal that we rejected. The Planning Commission heard it back in
May 10th?
May.
May 10th, I got it on the notes here.
Was he represented by Mr. Foley at that time?
No, he
No.
was not.
Is there currently a crop in the ground?
Yes, there is.
Madam Clerk, when would be the next available time we would be able to put this on the schedule?
Considering, I don't know if there is a noticing requirement for the planning department, but the submittal deadline for the August 8th meeting is today. So I would say the next time would be August 20.
So there is no, if it's continued to a date certain, we do not have to renotice it.
Okay.
And it's really up to, I mean, if it's continued over, the information is all
It's going to
available.
be, yeah, if it's going to be exactly the same information and it doesn't have that noticing requirement for them, then we can just have a motion and a second to table it to the 8th, and it can go on the next meeting.
I think we all have the concern that, we've watched people game this system to try to pull their crops early or hold out a little bit longer. So that's never a good reason for a continuance. But if we could do it in a prompt manner, it's different.
I think continuing to the 8th would be appropriate.
Could you continue it to the where?
To the 8th, August 8th.
I would go ahead and
It's-
move that
It's
for this,
going to
Okay.
be, that won't work,
because you're going to be gone.
yes.
And
I
this-
will not be at the
So we'll
8th
still be a
meeting,
3-0 staff here.
and you'll be back to 3-0 again.
What's the next meeting from that? 22nd?
Yes.
So if we moved it to the 22nd of August, that'd be
I'll be
acceptable?
present, I'll be present for that.
I would move then to move this to the 22nd of August.
We have a motion, but we should have public comment.
So that also may give the appellant's attorney time to look at his schedule as well if we're going for the 25th as opposed to the 8th.
With the understanding too that it is not our intention to continually postpone these hearings.
No.
Okay.
Absolutely not. We have a motion on the floor. We have not done public comment on this item. Only call for public comment before we continue down this line.
Steve Snowden again. Good afternoon. The reason for the denial at the supervisor level, I believe, was because they did not believe my wife. They basically called her a liar by saying that there was no list that existed that people were signing. So Mr. Foley has put out a notice in the paper asking that anybody that was here to sign up, and we were compliant with everything else, except that I was in a coma from a bike accident, so that's all I'm saying is that he even has Channel 10 was here. And those are the reasons why we want to make sure that he can give that information to you. Because indeed there was another list, and people were signing it with the intent of getting called by the county for that, is all.
So we have a motion, and is there, I'm sorry, complete, sir. Is there other public comment?
Bill McManus. What's especially sad is we've got a whole room full, or a lot of people, who came down for this meeting. I was at the Planning Commission meeting when this was originally denied, and there were people there. They're concerned, they come to the meetings, they wait through long hours of tedious conversation, and they stay. And yet, this is probably one of the most egregious cases here. These people were almost a year late even submitting their application. And now they get more delays being turned down by the Planning Commission. Big surprise. But pay $500, wait till almost the deadline, try to get on the calendar for the Planning Commission, lose there, wait some more, pay another $500, and try to get on the agenda for the Board of Supervisors. You know, and by the time you go through 2 appeals, you've almost got 6 weeks of time eaten up. Meanwhile, the happy plants are growing in the sun. You know, no one else gets, cut slack like that. And the people who suffer with it have to go home again today and plan their lives around it to come back. And I'd be willing to bet money I don't have, they'll be back, because it means that much to them. So I know that there's probably all sorts of legal tangles and everything else about hearing it today. I don't know what happens to the majority since you've only got 3 supervisors here. Would it be, if you get 2 votes to deny, is that enough? Or do you have to do something? Do you have to have 3 because the recusal counts as a vote? I don't know. But it would be nice to hear that conversation, that 3 of you could settle this matter today, unless it has to be a 3-0 vote. At least think of the citizens who came here several times, and think of how long this has gone on. And is this the precedent you want to set for a bunch more that you have to do in the future? I sure hope not. So, thank you.
Other public comment?
Bill Wilson. Again, we're waiting for an attorney who couldn't be present today. Last time I heard, we had a right to be represented by an attorney. Even if you can't afford him, you have somebody. They appoint somebody. It is kicking the can down the road. I agree. But everybody should have their day and their appeal process completely done. Thank you.
There's no other public comment. We have a motion on the floor from Supervisor Mills to continue table this to August 22nd. Is there a second?
I will second.
Second from Supervisor Tofinelli. Any further discussion? All in favor?
Aye.
Aye. Opposed? No. Passes unanimously. I apologize to the people who came all the way down and waited, but we have to go by these regulations. So, thank you very much. We'll continue to the 22nd. Supervisor announcements.
Supervisor announcements. In compliance with AB 1234, chaptered as Government Code Section 53232.3D, this is the time for board members to report on meetings attended on behalf of the county and to carry out their duties as a county supervisor.
Mr. Mills. I was looking for my notes. I left them in the office.
Want to run and get them?
No, go ahead.
Okay. Wednesday, July 12th, attended the Eastern San Joaquin Groundwater Basin Authority in Stockton, where direction was given on the future role of the Groundwater Basin Authority, and the budget for fiscal year 17-18 was approved. And the Eastern San Joaquin Groundwater Basin Authority Directors Meeting, where officers were elected, direction was given to find a consultant for the GSP scoping on the facilitation services that will be necessary in action to adopt bylaws for the authority. Attended the tree mortality meeting in San Andreas, reports on status of various work projects and the challenges of the grant funding for private homeowners. And I know Supervisor Garamendi, you were there as well. It was Blue Lake Springs was having some real concerns with how it was being handled. It was being handled for them. July 13th, Thursday, met with Public Works and Community Service Area 4 over whether they can still be a part of the emergency declaration and the timelines to handle their road repairs this year. The CSA has developed a 5-year improvement plan and has high reserve funds available and has completed a survey of all of the culverts in the area for Public Works. Attended closed session meeting with Council of Governments on a personnel matter. Attended Copperopolis Fire District Board meeting. Preliminary budget was then approved. July 15th, Saturday, attended the FFA dinner at the request of the Calaveras Animal Disaster Assistance. July 20th, Thursday, met with the sheriff and his staff, Supervisor Tofinelli, and our CEO as a continuing discussion on their budget and staffing. Attended the Chamber of Commerce mixer at Realty World in Arnold. Staff attended the Foothill Fire Safe Council meeting in Murphy's. There is new funding opportunities coming up. July 21st, Friday, attended the morning session of the nuisance abatement hearings to better understand how that process is working. I did have some questions which were answered by staff. July 22nd, Saturday, spoke briefly at the Bobby Zimmerman funeral, thanking him for his service to the community of Copperopolis and Calaveras County. Bobby was a firefighter of the year last year in Copperopolis and passed away suddenly. He was given a firefighter's funeral. July 24th, Monday, met with Angel City Council member to discuss water. She was trying to get up to speed on water and water issues, and attended the special meeting of the Council of Governments to appoint Amber Collins as the next executive director. Thank you. Appointed our executive director last night. Thank you.
Mr. Clapp coming back, do we know? Gary?
Well, I was going to announce that we had a new executive director of COG, Amber Collins. Somebody stole my thunder. As part of the committee to interview and suggest her to the COG board. So looking forward to working with this young lady. She is very well educated in transportation and holds an engineering degree. So looking forward to it.
And
That's all I have.
thank you, Supervisor Tofinelli, for the heavy lifting on that, because it was you and some of the other staff members that went through that entire process to select the top 3. So thank you.
It's great, jeez. I attended the tree mortality meeting as well. McCombie River Association, we met over in Jackson. Attended a agenda review as well as many constituent meetings. But what I want to bring up is I attended last Wednesday, the CSAC, RCRC, and the League of Urban Counties had a conference on a cannabis summit, which I attended down in Sacramento. Apparently sold that thing out to counties in a matter of hours. And it was really interesting content. It was brief. As a about regulation, about what counties are doing, what they're not doing. And I came back with a couple takeaways. The first is, we often talk about the fact that we're the laughing stock, and actually I think that's absolutely wrong. I don't think many people are laughing at us. I found at this conference that people were asking us what we did, what we learned, how we're going about it. A lot of them are actually trying, and maybe it's because we're all so close to it, but a lot of them are actually trying to reach a regulatory framework like we currently have, with operating enforcement teams going out with a shorter abatement period, with our taxes. And so, we're close to it, and we know the bumps and bruises of getting here. But I will tell you, counties from Yuba, Butte, all the way up Trinity, San Joaquin, they were all there trying to figure out what we already know. And we've had to learn the hard lessons the hard way. But I think we have to stop talking about being a laughingstock to neighboring counties and actually talk about the things that we're actually doing. We've learned a lot, and the knowledge that we have is valuable. If anybody was laughing, it was more of a wonderment on how we went this far and then decided to sail back. I had one person interesting say it's kind of like Columbus turning around within sight of the New World. So it's a challenge, but it was a really good conference, and I was proud to think about the things that we've learned over the last 18 months of this process. So that's what I had to report. If there's anything from staff.
Just really quickly, I would echo on the tree mortality, just so the board is aware, we're getting ready to issue a notice to who we're going to choose for project manager for tree mortality. That's been in the works for some time. So that's around the corner, and then that will be brought before the board. Also, thank you for the update on the groundwater basin. As the board's well aware, you took direction or gave direction, and took action on the east side San Joaquin groundwater basin, and we put in our own application. We will be coming back before the board here within the next probably couple of months with an agreement, an MOU, possibly, or another type of agreement between that sub-basin, which includes Rock Creek Water District, Stanislaus County, CCWD, and it will be Calaveras County as well. So thank you.
Madam Clerk? Very well. Well, if there's no objection, we will stand adjourned. Thank you very much.